Did we just experience bloody November? By that, I'm talking about the wholesale rejection of so many big Second Amendment petitions that are out there. We're talking about felon issues. We're talking about hardware issues. We've got so many things going on. But what does it really mean? Guys, we need the context to understand what it means. We're going to talk about what got shot down, what is still out there, and importantly, what does this all mean by giving you the information and the whole view of the battlefield. So guys, let's get into it. So the Supreme Court's handling of Second Amendment cases in 2025, I think reveals a pattern that I can best describe as selective enthusiasm. The court has denied dozens of gun petitions while accepting exactly 2. I'm going to cover what those are very briefly, but one might say that the justices were in a bit of a denying mood when it comes to 2A issues. Now, starting back in June of 2025's denials, we had Snope versus Bruen. This is the case that presented Maryland's challenge to its so-called assault weapons ban. This is covering AR-15 style rifles. Maryland prohibits these semi-automatic weapons, and the Fourth Circuit, that's the Federal Circuit Court of Appeals that covers that area. If you remember, lawsuits originate in federal trial court, the federal district court, then it goes up to the federal circuit courts, then finally up to the U.S. Supreme Court, who is infallible because they're final, not final because they're infallible. That's an old quote. I'm not taking credit for it, but it's still very, very true. So Maryland prohibits these semi-automatic weapons, and the Fourth Circuit dutifully upheld the restriction, reasoning that these are so-called military-style weapons, which they aren't, undeserving of Second Amendment protection. Justice Caetano, however, wrote separately to suggest during the denial that the court will eventually tackle the AR-15 question in the next term or two. Dramatic foreshadowing. A judicial version of basically maybe later. Although that sounds a lot more definitive than maybe. Justices Thomas and Alito and Gorsuch dissented from the denial, preferring not to wait. So you had Thomas, Alito, Gorsuch. 3 of them were on board with hearing it now, presumably because they wanted to turn it over. Kavanaugh probably very open to turning it over, but for whatever reason didn't want to get on board at this particular point in time. And then, of course, we've got Amy Coney Barrett, ACB, Trump appointee, as well as we've got none other than Chief Justice John Roberts, who may represent a little bit of the wild cards in these situations, particularly those 2. We did a deeper dive in that case. Hopefully you're seeing a link to it up here right now if you want to see that deeper dive, but otherwise, onwards to the next body on the floor. Also rejected in June was Ocean State Tactical versus Rhode Island. This was the case that was challenging the state's ban on magazines exceeding 10 rounds. The First Circuit had upheld the restriction on historical grounds. The same 3 conservative justices signaled that they would have granted review. Apparently, however, outvoted by colleagues with more pressing concerns on the calendar. Remember, the Supreme Court generally only hears between about 1% to 3%. Usually, historically, it's about 1.5% to 2.5%, give or take, of the cases that are seeking their bandwidth. Okay, so it's a very low acceptance rate. Now, some people have called these hardware cases where we're talking about the legality of specific 2A hardware. Okay, so magazines, firearms, accessories, that kind of stuff. We're talking about hardware. This is opposed to maybe software, dealing with things like who's allowed to carry, who's allowed to buy, where can you carry, that kind of stuff. All right, that's another way of thinking about that. These so-called hardware cases, as some people call them, represent significant constitutional questions, as we all know that the court found for now a little troubling in the convenience to ignore. It's rejection of Worth versus Jacobson. This was the one concerning Minnesota's age of 21 requirement for public carry permits. Now, the Eighth Circuit had struck down the law. So the Supreme Court's denial actually, the good news is it left a pro-gun ruling intact. So this is a rare instance of denying a writ of certiorari. That's where someone's trying to petition the Supreme Court to hear a case, while the lower court already sided with gun rights. Okay, so all these other ones, the act of the Supreme Court not hearing it was bad for the 2A. Now, the reason why I waffled a little bit on why that's a good thing is because, look, this is only applicable within the Eighth Circuit otherwise. So by letting the Eighth Circuit ruling stand, that's great, but it's only binding in the Eighth Circuit. But if the Supreme Court took the case and then did the right thing, we could have had this be nationwide and done forever. You see the waffling? The justices also rejected Wade versus University of Michigan, where petitioners argued that universities should not qualify as sensitive places under Bruen. Apparently, the court remained unfortunately very unmoved by the prospect of armed college students, as well as perhaps professors and faculty and staff. October 2025 saw Missouri's ambitious Second Amendment Preservation Act met with judicial indifference. The state had attempted to nullify certain federal gun regulations and impose $50,000 fines on officers who chose to enforce them. Lower courts found that this violated the Constitution's Supremacy Clause. If you want to see a deeper dive on that, hopefully you're seeing something come up on screen. And the Supreme Court let those decisions stand without comment. Then arrived November, bloody November, when the court's denials accelerated from cautious to gratuitous. On November 17th, the justices rejected VLHA versus US or United States, which challenged the federal requirement that anyone manufacturing or dealing in firearms obtain an FFL license. In other words, you have to become a licensed gun dealer, subject to, no real Fourth Amendment and all these other sorts of waivers. The petitioner contended that the Second Amendment includes the right to manufacture firearms without government permission, let alone regulation, oversight, and everything else. An argument that the Ninth Circuit out on the West Coast had already rejected via its so-called ancillary rights doctrine, a phrase that sounds more and more authoritarian when you're denying fundamental questions. The court also disposed of and tossed 8 separate challenges to Section 922 sub G sub 1. That's the federal felon in possession statute from multiple different circuits. These included both facial challenges as well as what we call as applied challenges by non-violent felons. So facial challenge, just saying this law is always unconstitutional on its face, versus as applied challenges that says, look, in this particular fact pattern, it's going to be unconstitutional. Nope. All rejected. The message the court sent by doing this was pretty clear. The court was not interested in debating whether lifetime firearm bans for non-violent offenses comport with the Second Amendment. Thank you very much. Come again. The November 21st conference achieved what might be called peak petition saturation, with, according to a couple resources that I checked out with, 59 Second Amendment cases were on the court's docket for conference and review. This is when justices talk about, and we did a whole video that you're going to see right here, going through the behind the scenes deep dive, if you're interested, about how the courts choose cases. What's the history on this? What have Supreme Court justices and clerks spoken about what's the inside baseball on all of it? The November 24th order list revealed the court had denied exactly 3 of those 59, leaving 56 in place. There's one of those 3 that challenged Section 922 sub G sub 5 sub A, which prohibits firearm possession by unlawfully present non-citizens. So that's a very fancy way, I'm going to use the politically incorrect term now, of basically denying illegal aliens the ability to purchase, possess, keep firearms, a provision that the petitioner argued lacked historical pedigree under Bruen. The next case, Jenkins versus United States, was another felon in possession challenge. This one, however, was raising whether categorical disarmament of convicted felons survives constitutional scrutiny, so a little bit of a different take. And then finally, you had In Re Michael Fosha, which presented yet another Section 922 sub G sub 1 petition, supplemented, so that's the felon in possession, supplemented with a motion to make it go faster for expediency, for expedition. Apparently, the petitioner had hoped that somehow claiming urgency might move the needle. I'm not attacking the guy. I'm just very skeptical about whatever advice he was being given. Because ultimately, if not predictably, it did not. Now, as I already mentioned, those are 3 shot down, but there are 56 petitions surviving, meaning that they were relisted for conference again. So that means that these are kind of held in like a suspended state of animation. The justices might ultimately choose to hear some or none of these cases, and anything can happen. All right, so they're still alive. There's still a chance.
So you're telling me there's a chance? Yeah!
So that's all kind of the glass half empty, or maybe 99% empty, depending on what you want to look at it as. The court did accept 2 firearm cases, 2 affirmative grants, which is the other side of the story. We've covered both here. We've got Wolford versus Lopez. This is the one that challenges Hawaii's post-Bruen carry restrictions, including very wide bans on sensitive places and what they are that are so comprehensively defined that one might reasonably ask where carrying is actually legal. The case also strikes at the inversion, or what some people call, and this is a big one, this is a really big deal, because we're seeing this spread from state to state to state, and those of you who are watching the channel know that I've been hammering this for years. The vampire rule. Okay, the vampire rule. This is the you're not allowed to come in unless you've been invited thing. Just like a vampire. This is the one where you're not allowed to go into a business unless that business says a firearms welcome sign, right? The vampire rule. Because that's how gun rights work. That's how constitutional rights work, right? You're not allowed to use your rights unless someone explicitly gives you the permission, right? Right? And the government can control your property. That's the way this works, right? So the core question here is really deceptively simple. How far can states go in declaring locations off limits while nominally complying with what the Supreme Court has ruled in the Bruen 2022 decision? So this is a really big case because the court's answer and what it says will absolutely determine whether blue states, which right now are the very anti-gun ones, can effectively nullify public carry through geographic strangulation and the vampire rule. Next, we've got United States versus Hamani. This goes into section 922 sub G sub 3, which bars unlawful drug users from possessing firearms. The case involves marijuana users, including those operating under state legal cannabis regimes. That's a fancy way of saying cannabis, marijuana is illegal at the federal level, but it's lawful at state levels. And that doesn't change the fact that just because you're lawfully using according to your state, you are illegal according to the feds. There's very obscure exceptions to this, but you get the idea. There's a jurisdictional nuance that basically complicates the constitutional analysis here. The constitutional question that's involved in this case is whether a categorical ban on gun possession by habitual drug users survives the Supreme Court's scrutiny, and whether what quantum of proof of habitual use suffices for the government to disarm someone. So in other words, if you just got one possession ticket or whatever, okay, is that good enough? Because that's the way it works here in Wisconsin. If you get one ticket, you lose your concealed carry license, typically for a year, okay? And they may deny your handgun purchases as well, typically for about a year in my experience. But that's just one ticket. Is that the same thing as a habitual user? Right? So you kind of get some of the nuances here. And again, I'm giving you on this whole thing a very superficial take because we're covering a lot of ground. So I'm trying to do this really fast. But needless to say that this affects millions of Americans spread across a few dozen states that marks the court's really kind of first examination of drug-related gun prohibitions following Bruen and, of course, the Rahimi decision. By the numbers, you just want to see the big picture. There's approximately 50 Second Amendment petitions that were pending by the court's September conference. With November 21st conference alone, we're now up to 59. Across the entire 2024 to 2025 term, at least, and there's estimates on this, but it's about 70 different distinct Second Amendment petitions achieved docket status. So they got docketed as petitions for the Supreme Court. The court accepted 2. So about 2 out of 70 so far, granting an acceptance rate of about 3%. Very ish. Keep in mind, there's also questions about what you're calling a Second Amendment case. So for instance, if a firearm is seized and someone's contesting the seizure, or is that really a Second Amendment case because it involves a firearm, or is that more of like a Fourth Amendment or property case or a seizure case or something like that? You see what I mean? So there's nuances about where we try to draw these lines. Now, while the court has accepted 2, they have denied dozens so far of Second Amendment petitions. And again, most of them we're trying to reverse an anti-gun ruling from a lower court. So leaving the lower court rulings in place, which is what happens when the Supreme Court doesn't hear a case, that's bad. That's bad. And as we already talked about, there are downsides to even leaving those lower court cases in place as well for the Second Amendment, that few rare times where we do win the lower level case. So what does this all mean? Tom, give me the sum up. All right, here's the sum up. The broader picture reveals that the court exceedingly is selective about which gun cases merit reviews, notwithstanding the deluge of litigation in the wake of the massive groundbreaking Bruen case from 2022. Lower courts have issued, rest assured, over 2,000 challenges to gun laws. 2,000 challenges since Bruen handed down its new test, the historical tradition test. Yet the Supreme Court has largely abstained and stayed out of the fray, permitting circuit court splits to develop. This is where one circuit court rules one thing and a different one rules another thing. That's typically where Supreme Court gets involved. I've covered cases like that this year. Usually that's a pretty safe bet if it's a big enough issue to trigger the Supreme Court to get involved in the case. So the 2 grants that we have for this next term, the cases that we're going to be getting rulings on, obviously tells us that, look, they're not done with the Second Amendment. They're not done talking about this, potentially expanding Second Amendment rights and pushing back against these states, all right? So for all those people saying the Supreme Court's doing nothing, look, just that's not true. Are they doing as much as I would like? Absolutely not. Let's be clear, all right? But it's not like they're doing nothing either, all right? That's just simply wrong. And for those of you who watch and pay very close attention to the Supreme Court, whether it's on business issues, tax issues, patent issues, whatever it is, First Amendment issues, Fourth Amendment issues, you might say that this is business as usual, and you may not be wrong. Look, the war is far from over. It's still very much going on. We are winning for the first time in possibly ever. We are winning, but anything can still happen. I appreciate you sticking around this longer video because I had so much ground I want to cover all at once because I didn't want to just give you the denials. I wanted to give you the context and everything else behind it. Let me know what you think about that. Drop a comment down below, share the video. Be sure to hit that like button. We're going to close out with our ever popular quote of the day. This one comes from none other than Gandhi, who, talking about the English Arms Act of 1876, this was the disarmament of India, keep in mind, was part of the British Empire back then, quote, "Among the many misdeeds of the British rule in India, history will look upon the act," the disarmament, "depriving a whole nation of arms as the blackest." I appreciate you sticking with me. I'll see you in the next one. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.